Welcome aboard Rocket Ship, the platform with the most relevant content for competitive examinations. This is Rocket Ship IAS Lab, and we would take up another question in our ongoing series on answer writing for general studies papers of civil service main examination. Specifically, we would take a question that might come in GS paper 2 of civil service mains. Let us read out the question together. Discuss the multifarious benefits of alternative dispute resolution mechanism. What are the obstacles faced by ADR in India, and what suggestions would you make to improve and streamline ADR in India? This question, the first part of the question, essentially establishes the very theme of the question, that the benefits of the alternative dispute resolution mechanism are multiple, that they are multifarious. In the second part, it talks about what are the obstacles that ADR faces despite the potential that it has. And in this sub part of the second part, actually, or you could even call it the third part, in the third part you are tasked with making suggestions to improve and streamline the ADR process in India. Fortunately, here we have an observation where here we have a quote paraphrasing Gandhiji himself about the very perspective of the ADR mechanism. So, he observes that the true function of a lawyer is uniting parties who were divided. You can well understand that the conventional litigation process, it is often acrimonious, that is, it is often bitter, and ultimately it leads to some form of, you could say, ill will, if not outright enmity, between the parties even after the whole litigation process is over. And Gandhiji, a moral absolutist, he argues that the whole process, the whole system of law should be based on a process that would ultimately lead to some sort of conciliation, some sort of rapprochement between the parties, rather than leading to a bitter taste afterwards. Gandhiji's observation above establishes the very theme of benefits of ADR. Now, defining ADR, ADR encompasses mechanisms for resolving disputes outside formal courts or even before starting litigation. So they are some sort of, you could say, alternatives, as their very name suggests, alternatives to the formal judicial formal court system. It uses neutral parties generally to help the parties reach an agreement or help them conciliate, that help bring a rapprochement between the parties. ADR, that is alternative disputes resolution, it includes mechanisms like arbitration. What arbitration essentially is, it is a system, it is a like you could say a process where a neutral third party settles the dispute on behalf of the contesting parties. Second comes mediation, which is disputes settled through involvement of the parties themselves. Parties involved, actually. The parties involved themselves settle the dispute with the help of a mediator, actually. Then comes conciliation, a less formal, more amicable setup with focus on disputes of civil nature. What actually happens, conciliation is generally, you could say, it is generally adopted for disputes which are of intimate nature. For an example, some family matters, things like those, there we go for conciliation. Then for India's particular, you could say, environment, there is the Lok Adalats, which is an invention that suits India's convention, that is India's culture, you could say India's tradition. Have a statutory standing. The Lok Adalats have been given a statutory basis, that is legal backing, under the Legal Services Authority Act. So these are some of the mechanisms under ADR. Now, talking of the multifarious benefits of ADR, what are they? First, it preserves social capital, amicable settlement over acrimonious litigation. Recall Gandhiji says that the real function of a lawyer was to amicably settle the disputes so that the parties could be united, they could be brought together again. So ultimately ADR, rather than resorting to acrimonious litigation, bitter litigation, it leads to some form of conciliation between the parties so that it ultimately the social capital is preserved. Then, as you can easily mark out, it relieves the burden of judiciary. You are certainly aware of the jam that of the case log that India judiciary faces, which are more than 3 to 4 crore cases actually. Probably it is reaching 4 crore or even more. So ADR, it like bypassing the normal court system, it reduces the burden on the judiciary. It signals business friendly governance, especially in matters of, for example, tax disputes or similar commercial disputes of commercial nature. It would ultimately mean that it would signal that India is open for business and it's business friendly. For example, a foreign investor or a company won't have to face the brunt of India's convoluted judicial process, convoluted litigational process. Then there is greater chances of the award being respected, as it is a win-win situation. Generally, ADR is supposed to create a win-win situation, so ultimately both the parties would be mostly satisfied with the awards of the ADR system. Then it's also important to recall that it frees resources which are otherwise entangled in disputes. For an example, take tax proceeds or tax disputes. Tax disputes essentially means that much of this resource, for an example, a particular tax payable to government, a tax that could have been received by the government, it is tied under litigation. So ADR would ultimately it would free this tax proceeds to be spent on something of you could say that is of urgent need. Now, taking up these points in detail, we certainly agree with Gandhiji that ADR being a non-acrimonious process leads to conciliation between the parties and thereby it preserves the social capital. Now, giving a real life example, the 2024 National Lok Adalat settled more than 2 million cases, reducing the case burden of our courts. Actually, its success was still of greater magnitude actually. It settled almost 1.45 crore cases. If I am not wrong, it was probably 1.45 cases. The 2024 National Lok Adalat had settled 1.45 crore cases, of which 1.25 crore cases were before litigation stage. They were yet to reach the courts. So you could have understood that without this Lok Adalat, so many cases would have ultimately reached the you could say on the docket of the court, and it would have led to a still greater jam, greater log and delay in India's judicial system. It signals a business-friendly governance, especially in commercial disputes. This would make India an easier and more lucrative venue for doing business. You can make out that we are talking of things like ease of doing business and making India a more business friendly, a more investment conscious decision, someone who actually protects the rights of the investor. Now, a report says that by 2017, almost rupees 5 lakh crore was stuck in, almost 5 lakh crore was tied in tax disputes. Even a fraction realized through ADR would have helped expenditure on capital and welfare schemes. Actually, we were confident about the 2017 data, but probably by 2023-24, this tax dispute amount has even reached to rupees 11 lakh crore. 11-12 lakh crore. That you can understand, that's a very huge amount. And if even a fraction of it was available to the government through the ADR mechanism, the government could have used this huge amount, even the fraction of 12 lakh crore rupees, on essentials like, for example, spending on welfare measures, or for creating capital assets like infrastructure, or for even reducing its own revenue deficits, things like those. However, despite these potential, the ADR mechanism faces various obstacles, structural and cultural. Structural, as you can understand, it's due to the very design, the very fashion of the system, and cultural, that has got to do with people's behavior, people's convention, people way of doing things. First is the constitutional aspect, actually, the constitutional issue. What actually happens? The appeal jurisdiction of high courts. Actually, sometimes high courts do not consider the ADR mechanism as part of the judicial system. What they think, actually, that the ADR system bypasses their, you could say, their jurisdiction, and the high court, being constitutional courts, have this position that ADR mechanism cannot bypass them, and ultimately they accept appeal against the ADR awards, and this would defeat the whole purpose of ADR system. Then there is government interference. Sometimes the government does not respect its own rules. There are frequent rule changes, as we would see later from the example of the Vodafone Idea case, that because of these things, government interference, the whole purpose of the ADR system, actually the government does not respect the ADR system, the ADR awards, and so on. Then there is a general lack of awareness about mechanism, about its mechanism and its benefits, the benefits and mechanism of the ADR system. Actually, people are not even aware that the ADR system is available to them in their particular cases, and because due to this, you could say, lack of awareness, they do not reach the ADR forum. There is obviously a lack of trained manpower. Actually, the ADR system is yet to come up in India, and therefore there is a scarcity of experienced professionals in this area. Now, explaining these points, you can understand very well that by virtue of being constitutional courts, the appellatory jurisdiction of high courts and Supreme Court cannot be bypassed. We are essentially talking about high courts, but still we are including Supreme Court too here. This often leads to arbitral awards being challenged, and this defeats the very purpose of ADR. We would like to add here, a similar condition had appeared in the case of tribunals too. When the tribunals were just coming up, the high courts were taking this position that there being constitutional courts, the tribunals could not bypass them, and ultimately they were taking up, you could say, some of the appeals against the arbitral awards. And as you can well understand, that this would ultimately, you could say, defeat the whole, you could say, the whole objective of creating tribunals in the first place. That if they had to appeal, if the tribunal awards could be appealed in the high courts. It's happening same in the case of the ADR mechanism too here. But fortunately, the Supreme Court is taking this position that the High Court should respect the awards from ADR system. And in time to come, probably we would see the ADR system being accepted as a part of India's, you could say, alternative judicial mechanism. Governments have many a times employed their sovereign power to challenge otherwise sound ADR settlements. This has raised questions like retrospective taxation, respect for bilateral treaties, etc. We are essentially hinting at the case of Vodafone Idea. Actually, this is a private company which is well known as a telecom company. And what happened when there was some form of merger or acquisition in Vodafone? The government of India insisted that there was some tax that was, you could say, payable to government of India. And even while, and it was essentially a theatre of the absurd going on in India, that even while the Supreme Court of India had ruled in the favor of Vodafone Idea, the government of India insisted on and actually got the law amended to give it retrospective effect, that is back effect, and it demanded tax from Vodafone Idea. And even while the whole Vodafone Idea deal was protected by a bilateral investment treaty with, if I am not wrong, with Netherlands or Belgium, maybe Netherlands or Belgium. Even then, government of India took a very intractable position, and ultimately the private party appealed against government of India's, you could say, tax demand in a foreign arbitral tribunal actually. And the arbitral tribunal, again, as you can well understand, probably you are aware of this, the arbitral tribunal ruled against the government of India and in favor of Vodafone Idea. And as you can understand it, not only India lost a claim on the tax, India lost its face also. It was a loss of face for the government of India. And as the condition, as the present precarious financial condition of Vodafone Idea would have you make out, we can easily forget to retrieve any tax from Vodafone Idea. Now, there is lack of trained manpower as ADR is yet to pick up in India. Now, we have talked about some of the obstacles faced by the ADR mechanism in India. Now, let us make suggestions. What are the suggestions that could be made to, you could say, streamline and improve the process? We must clarify the legal standing of ADR, is essentially the constitutional position, that where the ADR mechanism stands in relation to the high courts, essentially in relation to the higher judiciary, whether appeals are possible or not. And we are suggesting that we should restrict appeals only on substantive grounds. Only if there is, you could say, a question of substantive law, for example, something related to natural justice, for an example, the sanctity of the process, procedural sanctity, procedural justice itself, etc., or when the amount involved is quite large, only then we should allow appeal to the high courts. Else the appeal would certainly lie to the Supreme Courts. Then promise to respect the promises made to our counterparts and reassure businesses of fairness and due process, because many a times the ADR mechanism has direct bearing with the private business, with the private investment, for example, the private investor. So we have to essentially assure them that we would respect whatever rules we are making today and won't change the rules arbitrarily. Then the taking up the question, like the issue of untrained manpower, we must start training programs in conjunction with industry and academia, so that we can train the you could say ADR professionals, etc. We should also create awareness about the ADR mechanism and its benefits among the people, so that they would ultimately go for ADR rather than go for formal litigation. This is the suggestion that we were making, so that we can realize the potential benefits of ADR, which includes preservation of social capital or reducing the burden of case log on the India judiciary, and also making India a more business friendly destination, so on. This is all about the ADR mechanism in India. We would reassemble for the next lecture in a few days. As usual, we wish you all the best. Thank you.